Software developers are very, very focused on outcomes. Lawyers tend to be more obsessed with process. So that's what Garfield is. You can think of it as a sort of AI lawyer in a sense. From the moment that they started the claim to getting paid, they spent less than 4 minutes. Now, 4 minutes to get 7,500 quid is a heck of is an enormous time saving. Whereas if you had to engage a law firm, you have to spend an hour at least to even get anywhere near meeting a lawyer. And so if you can safely automate what humans do, then I think you should. But then of course it's got to be safe. Yes, I think one of the things about AI is it's going to improve the average quality of lawyering. Just like no one thought to put wheels on luggage until fairly recently. And I'm old enough to remember when everyone had to carry their luggage around by hand, and now you'd regard that as insane. The biggest barrier to justice is cost, and by far the biggest driver of cost is human time, which is expensive.
Most lawyers I speak to want to use AI on the hardest problems first. Complex disputes, complex drafting, complex judgment calls. But that's usually backwards. In this episode, I'm talking to Philip Young, the co-founder of Garfield AI, world's first SRA-regulated, AI-powered law firm that helps people recover small debt claims in England and Wales. We get into what Garfield actually does, step by step, why this specific legal workflow is contained enough to make AI work safely, and where Philip draws hard lines on what should stay human, including advocacy and judging. If you're a managing partner, lawyer, legal ops lead, or you're building legal products, this is a practical conversation on where AI holds up in real world and where it doesn't. So let's get into it. Yeah, so thank you so much for doing this. I was really excited when you agreed to come on the podcast. You became quite a celebrity over the past 8 months, I think.
Oh, no. And not my ambition, that's for sure.
Yeah, that I also got from all of the podcasts that you did. Like, you didn't want to become a celebrity, and you were quite surprised by what happened.
Yes.
But before we start talking about Garfield, I wanted to ask you, because this does feel like a deliberate marriage between legal judgment, reasoning, experience, and then on the other hand, systems thinking. And how did the co-founding team, so Daniel and yourself, how did you guys come together? And why do you think that this combination matters so much?
So in terms of how we came together, when I decided that I wanted to build something, I realized that although I can code and I have quite a lot of sort of technical know-how, I'm not a professional software developer, and I knew I needed additional people with additional skills. And so I decided I needed a technical co-founder, and then I went out looking for someone. And what I essentially did is I interviewed a bunch of people, and Dan was the obvious standout candidate. We obviously just clicked, and I think it's very important when you start any sort of business that the founders get on really well together, that they have a good relationship, because you're going to be working closely with someone for a long time. And I think he really liked the idea of the product, and he loved the access to justice side of things. He thought it was a really good challenge, and obviously no one ever tried to build anything like this before, so he was very enthusiastic. At that point, it's fair to say he was intending to go off and do his PhD. It was all ready to go. You know, he was going to Australia to do this PhD in photonics, which is a sort of area of sort of quantum physics, very interesting area. And he did eventually go off and do that, but he didn't last there very long because he'd enjoyed Garfield too much. So he came back and continued the project, which was excellent, because we missed him when he left. So yeah, I found him the traditional route. I just went out looking for somebody with the right skill set, and Dan was the guy.
And probably as you mentioned in our previous call and also in this answer, basically the understanding that there needs to be two types of experiences here is coming from your understanding of both fields. Can you talk a little bit more about that?
Yeah, I think it really helps. So if you're going to build a law tech product, I think it's very, very important that you have somebody with really good knowledge about the area of law and practical reality of how it operates in order to build it. And then you've got the challenge of, well, if you had a founding team that had a lawyer and a technologist in it, you've then got to make sure that they can work together really seamlessly. And one of the challenges there is that lawyers don't necessarily think in the same way as software developers, which is interesting because I think there are very close similarities in the way you approach things. I could always return to that topic if you want, but it helped in our case that I'm not just a lawyer. I also have written a lot of software in my time, and I learned to. So I was brought up in the 1980s. I got an 8-bit computer. I learned to code on that, and then I learned C, and then I learned C++. And so I've always been really interested in writing software, and I found it quite an enjoyable thing to do. And so I could sort of convert legal concepts into code for the guys relatively easily. And also I understand a lot of the challenges in writing software. And I think that's really important too, because I think if you haven't tried to do it, you don't understand why sometimes something that might appear to be very easy to fix might take a day or so to fix, or something that appears to be really difficult can be done really quickly. So I think it really helps that way around as well, so that when you're doing inevitable bug fixing and those sorts of things, you can understand the real scale of the problem. So yeah, I think that's really helped us, the fact that I've been able to sort of translate legal stuff into language that the guys understand.
The languages that you mentioned, C, C++, that's pretty awesome. Even for today's standards of engineers, a lot of engineers do not know these languages, and there's the difference, writing something in JavaScript and writing something in C++. It's a big difference. Knowing how to code in C++ or knowing how to code so it works and it's good is very, very different things. So that's pretty admirable.
Well, thank you. Yeah, I mean, I've had to learn some new languages as a result of Garfield. So I've learned Python, which I rather like Python, although I don't like the speed. It's too slow. Although there is something called, is it Mojo? Something like that, where they're using Python syntax and they're writing the language in a much more efficient way. So it is processed far more quickly. But I've also had to learn TypeScript and JavaScript, and I personally dislike those languages intensely. I think JavaScript is a unholy mess of a language. And we did an early stage. Our first prototype we built in Flutter, because at that point we were thinking of this as a mobile application, and then we decided actually it's a desktop application. And as part of Flutter, I learned Dart, and I really like Dart. Dart's a very elegant language. It's Google's done a really good job of what they've done there, and it's. I felt a bit sad that we had to abandon Flutter because I was enjoying Dart so much. But no, I think this is also part of being a lawyer, that you do strive for sort of elegance in a way, and you strive for sort of elegance in the way you present your arguments and how you compile your case as a litigator to try and make it as persuasive as possible. And I think software developers also strive for elegance. They try to make their code as neat and compact and maintainable as possible. They try to ensure that code is not some horrible rambling mess, but there's lots of discrete functions, and a function only does one thing. There's all these sort of principles of clean and agile coding that I think are very analogous to the way that lawyers, if they're being good lawyers, should operate. And so I therefore sort of carry sort of some of my legal baggage into the software engineering side of things. So I get a bit upset if ever I see code that's not very efficient, and fortunately all my guys are brilliant, so they write much better code than me. Yeah.
You mentioned a few similarities between the professions. What are some of the things that you see that are differentiators, that are differences?
I think systems engineering is a big difference. So if you look at what software developers seek to do versus how lawyers sort of operate, there is a subtle but profound difference in the way we think about systems. Software developers are very, very focused on outcomes. They want to tell a computer to do precisely what they want to get out of the computer. Lawyers tend to be more obsessed with process. And you can see that actually if you just look at something like the Civil Procedure Rules, the White Book. Most of the White Book is devoted to process, and hardly any of it is devoted to outcomes, i.e. enforcing judgments. And that's a very remarkable thing. You could argue it might almost be better if it was the other way around. I think that can sometimes lead to misunderstandings when lawyers talk to software developers, because we lawyers will think a lot about the sort of the messy part of law and how humans interact, and all of the possible edge cases that can come up, where software developers will often sort of say to themselves, well, a lot of these edge cases is like 0.001% chance of them happening, therefore we're not going to need to cater for it. That we'll work on the majority of how the process is supposed to lead to good outcomes first. And I think as well, lawyers don't always think about how to make things the most efficient. So I mean, if you look at the world we're in at the moment, so small debt claims, during my time in practice, lots of very worthy people created something called a pre-action protocol to deal with debt claims. And it's very worthy, but all it essentially does is add another layer of cost and complexity onto a process that should be simple and straightforward. And I don't believe in a million years somebody with system engineering background would ever have thought that was a good idea. Simply, so it doesn't really help. In fact, it's quite amusing that it prescribes these documents have got to be attached to a letter of action, and it's about 9 pages worth of documents, which are only ever filled in and returned by debtors in a tiny minority of cases. I think we've seen in the hundreds of claims we've done, I think we've only seen like these documents returned twice. So there is all this rigmarole that is fundamentally useless. And I think I've been saying to the powers that be that actually, as we're moving into an AI age and legal practice is going to be built very much on software, we really need to have software developers in the room from now on whenever we amend the civil procedure rules. And that's not just to ensure that when those rules are amended, that they're amended in a way that systems can handle, but also just to think about it from a systems engineering perspective and say, what are we actually trying to achieve here? Is this actually a good idea, or is this just make work? And I think that would be a valuable thing to do. That would probably fill the legal profession with horror, the idea that a systems engineer is looking over their shoulder.
Coming from a Silicon Valley.
Yeah, exactly.
That's a great segue into Garfield AI. I'm pretty sure that almost everybody heard the name, probably because of the publicity, but I guess that not everybody knows exactly what it's about and what it's actually not trying to do. Could you try to explain that in your own words?
Yeah, so Garfield, so our initial product is something that helps individuals and businesses recover their small debt claims. So this is any sort of debt up to £10,000 in England and Wales. And Garfield essentially does what a law firm would do for somebody with that sort of claim. In other words, it helps the user draft the initial correspondence that has to comply with the protocol that I mentioned. If that doesn't lead to a good outcome, it drafts for the user the court documents to start proceedings, so the claim form particulars, and files those at court when the user's happy with them, and then helps the user depending on where the claim might go from there. So the majority of claims when you issue a claim form are paid or they're ignored. So if they're paid, great, you don't need Garfield anymore for that. If they're ignored, Garfield helps you by applying for default judgment and gets a judgment, and then in due course sends it to the debtor and says pay up please. Alternatively, if the claim is admitted, Garfield helps you deal with the admission, and if a claim is defended, Garfield helps you deal with the defence and deals with the next stages up to the edge of the hearing. So Garfield deals with allocation, document production, and in due course does you a bundle for the hearing and a skeleton argument and all of that. And that's the initial product that we've been working on solidly for a couple of years, and we are going this year to be releasing some further products because we built Garfield in an intentionally modular way, and it's relatively straightforward therefore to extend Garfield to deal with other sorts of claims. So that's what Garfield is. You can think of it as a sort of AI lawyer in a sense. Obviously it's got some advantages over a real lawyer in that it's available 24/7, so you don't have to wait to make an appointment, you don't have to wait to hear from the lawyer, and it's an awful lot cheaper and more efficient. So yes, that's what Garfield is in a nutshell.
And what are the characteristics in this process, in this area, that made AI first approach possible?
So I think that the biggest reason that using AI is this is a helpful use case for AI is that small debt claims are a they're a chronological series of very well defined stages, with a reasonably finite number of inputs to each stage and a reasonably finite number of outputs. And that lends itself naturally to an AI-powered solution, because you're not trying to deal with an infinite range of possibilities. And I mentioned it elsewhere, but my co-founder Dan has this wonderful phrase he uses. He says it's a relatively closed. It's a series of relatively closed problem spaces, which I just love that. That's good science speak that I've adopted, and that means that you're not trying to deal with an impossibly large range of variables. You're dealing with quite a structured process, and you can therefore use LLMs plus, in our case, a deterministic expert system to manage a user through those stages and deal with the likely range of possible things that might happen at each stage. This is obviously in contrast to the work I used to do, which was the opposite end of the spectrum, where it was really big ticket, complex litigation, where although there was a structure, the structure was much looser and more flexible, and all sorts of very unusual things could happen at each stage. As it happens, I worked out how you could build a system to handle that too, but I think we're nowhere near that in terms of the current state of technology.
That's, how should I phrase this? I have a lot of talks with law firms because I work with law firms. That's pretty then, makes sense to talk to a lot of law firms. But when we're talking about what is a potential for AI to handle, they're always coming up with these big complex procedures. We can't blame them because there's been billions thrown into marketing, into convincing us that basically AI can solve everything and replace any kind of knowledge work. When you're thinking about which other claims you would like to handle in the future, without asking you to spill the secrets, what are some of the things that you are looking at? What are some of the things that you are not looking into?
Well, we wouldn't jump straight into the sort of work I used to do. So we wouldn't jump straight into really big ticket dispute resolution or really big ticket transactional work, because I don't think you could just jump straight into that. I think that would be incredibly risky. So our approach is, because we're an access to justice product at our heart, we're going to look at other areas where there's significant unmet legal need and where Garfield could help either individuals or businesses. And that tends to mean it tends to be less complicated things, because most people's legal problems are not giant multi-billion pound problems. They are the problems of everyday life, which tend to be reasonably straightforward. But nevertheless are expensive with the current way that legal services are delivered to acquire. And so I think we're looking very much at sort of in comparative terms, the less complicated things. And I think that's a good place to start. And we're also looking at sort of taking a more vertical approach. So in due course, we'll extend Garfield so that it doesn't just do small debt claims up to £10,000, but it moves on to do fast track claims between £10,000 and £25,000. And actually, we've had quite a lot of requests from my existing user base to be able to do that, because obviously, having seen Garfield can help them at the level they're at, they then will go, "This is great. Can we move up? Can we do the next layer of claims? Because we don't know what to do with those either." And at some point, we will do that. We will enable that. But this is probably where the cautious lawyer in me comes out, and that is, I don't think you can run before you can walk. And I think you've got to take things in stages, and you've got to prove each thing as you go, and then move on. Otherwise, there's a danger you're just going to produce products that actually don't work properly and aren't great for users.
There's a lot of talk about becoming AI first. There's a lot of, I feel like, and this is coming from a non-lawyer, so bear with me, but I feel like there were two traditional paths. As a lawyer, you could join a law firm and then you would go into a hierarchical organization, or you would go and be an in-house counsel in a company.
Yeah.
Feels like And this is literally coming only from my experience from talking with lawyers, that some lawyers are now going out of law firms trying to create or build their own AI first law firms, which would be, not really traditional. What is some of the pre-work that needs to happen in order for the firm to have some sort of foundation that you can then, add AI on top of?
Yes. So I do agree with that. I think that at least in England, we have a split legal profession. We have solicitors and barristers. And as far as solicitors are concerned, what most people would do is that they get a training contract, normally at a law firm. Sometimes at places like local councils that also offer training contracts in their in-house legal department. But on the whole, with law firms, and then lawyers would leave the law firm if they didn't want to continue in private practice and then go in-house. And they pursue an in-house career instead. And there'd be a very small number of lawyers who were litigators who would sometimes cross to the bar and requalify. So in terms of setting up an AI-powered law firm, obviously I've only got experience of doing it once, but it's been a very interesting experience. I think you've got to begin by asking yourself what problem you want to solve. I think that's the first and most important question. And I had a very clear problem I wanted to solve, and I had a very clear idea of how I wanted to solve it. And then once you've got a problem, then you need to work out what team you need. In my case, I knew I needed a technical co-founder, and in due course, as we worked on Garfield, we expanded the team to add more and more sort of skill sets as we needed more skill sets and more people. So I think you've got to find the right founders. And I think it's really important that you do find the right founders, because if you don't get on really well, then you probably find it won't work. And in fact, I think I was reading some story in the press about some people that left OpenAI and they've all fallen out, and some of them have gone back to OpenAI, and that's sort of what I mean. All the founders have got to get on really well together. That's really important. And then you've also got to think about the structure of it. So I don't think it's any coincidence at all that here in England, we've got an AI-powered law firm as a world first, and it's an ABS, an alternative business structure. And lo and behold, Arizona, that also allows ABSs, has also got something that is a bit like an AI-first law firm, although they say they're not a law firm, but they look a lot like a law firm to me. And I think that's important, because I think the traditional way that law firms were funded out of partner capital is not... It's basically hostile to the idea of technology products, because the way that law firms finance themselves, partners want to take their profits out after the year has ended. They don't want to reinvest it in technology products. And so I think that's why you need something like an ABS, where you've got founder money in and you can also attract external capital. And then you're into a question of what capital to attract. Now, I have been besieged by VCs wanting to be my new best friend since last May, when we came into the public arena. But I have sort of scrupulously avoided VCs, and there's reasons for that. And instead, I've gone down the angel route, and I've accepted money from people I've known for a long time and I trust. And I think that's quite important, because you've got to decide what incentives are going to be in your business, because they will drive behaviour. So if we'd had VC money, I imagine I'd been under enormous pressure to scale a lot quicker than we've actually done, because we've taken a very go slow to go fast approach, which is sort of classic software development speak for you want to make sure that it's working really well before you start allowing 10,000 people on the platform, because otherwise, if you have a problem, you've got 10,000 problems, not just one problem. So I think that is a very important thing to think about as well, which is what money you're going to accept, what are the incentives that come with that, how is that going to drive behaviours, are those behaviours going to help what you're doing, or are they actually in the long term going to hinder it? So those are the sort of some of the factors to think about. And then on the technology side, you've just got to think about what technology you're going to use, what frameworks, what platforms, what you're going to build for. Some products will be, I'm sure, mobile only, some mobile first, some desktop first. And you've got to think about, as we did, where we moved from Flutter to a more sort of traditional approach where the front end is all React and TypeScript and the back end is Python and various other technologies. You've got to think about what you're going to build with and what's going to be best for what you're building. Obviously, if you're building anything with AI, you're probably going to be in the Python universe, like it or not. So, yeah.
Yeah, I wanted to say something about Python, but I rather not. I don't want this to
go for it. Yeah. I quite like Python. As an old timer, I feel like an old timer now. To have sort of modern IDEs with everything that comes with them, and now LLMs built in, that things like Claude Code.
Yeah.
I started in the days where with BASIC, where you typed in 10. Print hello 20 go to 10, and it's just like a completely different universe. So much easier nowadays to write code.
Yeah, true. It's funny how Python became the go-to language for basically everything we're building today. But like 3 years ago, I remember we had these debates within the team that I was at, and we were like, we got a project that everybody had to learn Python, and we were like talking about how do you feel about Python, and we were all like, yeah, it's cute, it's like a baby language, it's pretty slow, but and now everything is around Python. You really can't get away from it.
Yeah. I think is it Mojo? I can't remember what it's called. Where they're basically I don't know if they're trying to turn it into a compiled language or not, but they are rapidly accelerating the speed of Python, and I think that would be a complete game changer, because if you can write Python code and then run it at sort of 10 or 100 times the speed that it presently runs, that would be huge. It would actually have probably a tiny but measurable effect upon the world economy.
Yeah.
Yeah.
True. I heard a lot of people are trying to rewrite some stuff then in Rust.
Okay, yeah.
The problem is that the frameworks are not written in Rust. So if you want to integrate with all those different tools, then it becomes, you need to write much more code.
Yeah. Well, that's always the thing, isn't it? There comes a tipping point where a technology's got so much ecosystem around it that it becomes the default. I mean, I find it amusing that there are bits of Python that essentially just talk to files that were written in C++ and compiled, because they're so much quicker. Yeah, and I mean, I come from an era where every bit of processor power and every bit of memory was absolutely critical. And when I started in the 80s, you'd do stuff like you'd store memory in the screen buffer. Because if you'd only got 32K or 64K to play with, literally every single byte was valuable. And that's the reason why the games in that era, they had all the flashy screens when you loaded them. That was actually, you were seeing, that wasn't just somebody thinking, I'll make the screen go multicolored for fun. That was thinking, I've got to shovel this into memory somehow. I'm going to put it in the screen buffer.
Yeah.
And I explained that to the young guys nowadays, and they're bemused, because I mean, you bring in a package in React and it's like 0.5 gigabyte or something. You only use 2 functions in it.
Yeah, it's like you do npm install, and at the point when you do that, basically I found the Giphy that really depicted that really nice. It's like, the barn doors open and there's like millions of geese that run out. That is literally npm install.
Yeah, exactly. Yeah. You might only use one of the geese.
Yeah. I wanted to ask you a few things about, so you gave us the overview of what is happening when a user uses Garfield. But I wanted to ask you, and again, if you don't feel comfortable answering this because it's going too much into your PI, I'm okay with that. But I wanted to ask you, how did you design the hard boundaries within the system? How did you design human in the loop? Was that like a one-time thing? I already know the answer, but I have to ask it in that way. Was that a one-time thing, a linear thing? Okay, we're going to have a human in the loop here. These are the boundaries we're going to have around the system. Or did some things develop as you were going?
I think part of the design philosophy from day one was to be careful, because if you're going to be the first, you have an obligation to be careful, more careful than perhaps people might be in like 5 or 10 years time, when this technology is much more mature. And we took the view early on that at least to begin with, there should be a lawyer looking over everything before it's sent out the door as a sensible safety precaution. And so that's what we do. Now, that's not the end state of this. It's always been envisaged that over time we will get to a world where it won't be necessary for a human to check every document, and we'll move to more of a sort of risk-based sampling approach where a lawyer will look at documents where there is particular risk or the system has flagged them as requiring a human to review. And that's something the regulator is comfortable with in principle, and we'll see how we go heading towards that sort of world. There's also a sort of point about applicable law around that, because in this country at the moment we have a bit of a debate around a case called Mazza, which is going to the Court of Appeal in February, which may or may not impact upon to what extent we need a human in the loop. And I think more fundamentally, there is a societal level discussion to be had about to what extent humans should be in the loop for law tech products. And I think that's a sort of four-way debate between the regulators, between the judiciary, the government, and also sort of the populace as a whole, because they are the people who use legal services. And the reason I say that is because if we're concerned about access to justice, the biggest barrier to justice is cost, and by far the biggest driver of cost is human time, which is expensive, very expensive. And so if you can safely automate what humans do, then I think you should. But then, of course, it's got to be safe, which is why at this early stage I'm checking everything. Now, we internally have built something, we call it AutoCheck, but basically it's a system that we're improving and expanding all the time that checks documents that go out the door automatically. That doesn't replace my checking. It's a sort of extra level, but I'm also sort of checking AutoCheck. I'm keeping an eye on how it's working, and we'll get to a point, I think, where it will be possible with technology safely and confidently to quality check the overwhelming majority of documents. In which case, a human doesn't add anything. In fact, a human can actually make things worse because humans make mistakes, and you might find that the electronic system is accurate, but the human steps in and gets it wrong, which would be sort of perverse and amusing, but not great. So I think that's where we'll get to, and then there will be these sort of societal level questions about, are there particular things in, for example, litigation where you still have to insist on a human, and that's a sort of question that's above my pay grade, although I do have views on where you should and where you shouldn't. Which we could talk about if you wanted to, or leave to another time.
Could you elaborate a little bit on that?
Oh yeah, sure. Well, so I mean, I personally, this is my own personal philosophy. I personally think that, except for very small cases, advocacy should always be done by humans, and I also think that judging should remain a human exercise, except maybe for tiny cases. And I think that's because lawyers often think too, as we said before, lawyers think too much about process, but it's important for lawyers to remember that you're dealing with humans going through a human experience, and a lot of humans, they seek justice because they feel wronged, they've got an emotional stake in it, and they want to be vindicated. And I think you can only really be vindicated by another human who says whether you win or lose and why. So I think that's very important. And the other side of things as well is that in terms of the litigation process, in England we've got various documents that have to be verified by a statement of truth. Now, some of them are just purely administrative, i.e. I have served this document, signed the statement of truth. That is the sort of thing I think you can automate, because if you're serving documents automatically, there's no reason why you can't then automatically confirm that you've done that. Whereas there's other things where, for example, you might be giving witness evidence in writing, where it feels to me that whoever the witness is, they can't just automatically generate a document and send it out. I think they should stop and think about it and read the document and then sign the statement of truth. I mean, they don't have to sign it with a pen and ink. They can sign it over a computer, but there should be that process of reading and reflection that I think is important. So I think those are some of the examples of where the argument goes both ways.
Yeah, it's pretty funny that I'm coming from the technology, and I do agree with you. But in my own limited way, purely thinking from the technology perspective, because I know what the technology can do and I know what it can't do, and what it definitely can't do, and we're very, very far away from it. If ever we'll achieve that state, is understand the world.
Yeah. I, I think that's a really interesting philosophical topic because, in my mind, there's no doubt that LLMs have a form of world model in them. When you look at the way that they're built, they have these enormous number of dimensions, and all the concepts are vectorized, and so cat as a concept will be attached to tail and legs and eating mice and things like that. And so that is a sort of form of a world model, but it's a limited one because, for example, LLMs that are trained on text only will only understand it on a text level. And I think it's going to be really interesting when we see genuinely complex multimodal models appear, where LLMs have been trained on not just text but sort of pictures and everything else. And particularly when robotics leads to robots' data being used to train, because then you might start to have something that's a little bit more analogous to the way that the world model in our human brain with all our neurons operates. So yeah, they have it's a sort of Plato's cave understanding of the world. They sort of see a projection of it on a flat screen. Mind you, I had this debate with a neuroscientist, and he I think he was being a contrarian deliberately just because he's interested in these things, so he was testing it. But he was saying, well, isn't that totally analogous to the way humans operate? Because ultimately our understanding of the universe is mediated by things like light rays hitting our eyes, being turned into electrical impulses going into neurons. He said you couldn't look at a human brain and say, okay, well, basically we've got it's all been interpreted through a different interface. Was his point. And he said he said it's the old philosopher's question about what does chicken really taste like. Yeah, you only know because electrical impulses have come from your taste buds, and then they've been translated into the structure of your brain, how neurons fire and stuff. And it's a fair point, So
it's a fair point, yeah. One thing that we don't see LLMs are able to do is implicitly learn. Mm-hmm. So, okay, maybe I can try to explain what I mean on OCR.
Yes.
If you want to recognize a cat, you got to give it like thousands of pictures of cats, and then it will recognize the cat. But then you give it a lynx, right? Yeah. Or a mountain lion, which is kind of a cat, but it's not. So it will get very, very confused. So then you have to give it. It will know it's not really a cat, but it doesn't know what it is.
Yes.
So then you have to train it on thousands of pictures of mountain lions.
Yes.
And but human brains don't learn that way. We don't need that much data, that much information to be able to learn.
Yes, we're much better at analogizing. When you were talking about the cat and the lion thing, I was reminded of the comedy series Silicon Valley and the hot dog not hot dog joke, which is exactly the point you're making. But I mean, humans, obviously we've evolved a form of intelligence that enables us to learn with a lot less data and in a much more flexible way. And I agree with you. I think I'm sure this is what all the frontier labs are working on, but LLMs are essentially static. They're trained and then they're fixed at that point in time. And so the challenge is really getting to be more flexible and to learn as they go in a safe way. And if ever they crack that, then I think we are then in this world that people talk about of AGI and all of that.
Yeah. Okay, let's not go into AGI.
Yeah. We could go into a long discussion about underfitting and overfitting models and linear regression and all of that, which is really interesting, but probably beyond the scope of this chat.
Yeah, I think that a lot of the people that are listening to this podcast will tune off. We start talking about those things. But it's I gotta say it's very exciting to talk to a lawyer about those things. I've been working with law firms for a year now, and I haven't had a discussion like this with anyone.
Well, if it helps, there are plenty of lawyers who I've met as part of my odyssey through this world who are sort of similar to me in that they're really interested in tech and they've got some programming experience and they're interested in science. But I think we are the minority, and that's a bit of a shame because particularly going into the future, I think understanding of all this is going to be a lot more important.
That's a great segue into the question that I wanted to ask you in the end, but I'm just going to ask you now.
Yeah, go for it.
What do you think? What are the skill sets that are going to be really important for lawyers to have, not just within AI-first law firms, but in any kind of law firm of the future, beyond the obvious, you're going to have to understand how the technology works?
Yes. So I think it's always going to be important for lawyers to be good lawyers. I think that's always a foundation. So lawyers will still need to know their substantive law and their procedural law if they're litigators, and have all those basic skills, because at the end of the day, if they don't have them, they'll be outcompeted by technology anyway. And then on top of that, I think there's two areas of further importance. One is a better understanding of technology and the ability to use it. I think that's going to be really important, particularly as a lot of legal work going into the future is going to be on the back of AI-powered platforms and things like that. And so it will be important not just to be able to use those things, but to also understand, their advantages and their disadvantages, and their strengths and their weaknesses. And we've already seen plenty of lawyers fall foul of that when they're doing things like sending documents to court that contain hallucinations. And that's obviously a demonstration they've not understood the weaknesses of what they're using. And then the other side of things, I think, is differentiation. So lawyers, I think, going forward are going to have to provide a much more holistic service. And I've sort of spoken elsewhere about why I think lawyers almost need to be, in a lot of areas of legal practice, trained counsellors as well as just lawyers, because a lot of what you do as a lawyer when you're dealing with contentious work is trying to help people who are often going through very difficult times in their life get through that time, that process, to get to a hopefully preferable ending and a preferably better outcome. And I think a lot of that is, I mean, I always used to jokingly say, when you're in practice, a lot of it is like being a sort of amateur unpaid therapist. And I was no good at that. I tried my best and I was very sympathetic, but there's a limit to what you can do. And I wasn't trained to do it. And I think going into the future, I think we need to train lawyers to have that skill set as well. In part because I think humans will always want to engage humans in some areas of legal practice, but I think they will be looking for much more than just this is what the law is and this is what we can do next. So you have to provide a different type of service and a sort of more holistic service.
I wanted to go a little bit back.
Yeah.
Because there was a segue that we didn't take advantage of, which was, this is a big thing about Garfield AI is that you guys are SRA regulated.
Yes.
But when we talked about this in our chat prior to this podcast, I got to understand that was a two-way street with benefits for both ends. Could you speak a little bit about that?
Yeah, so we wanted to be regulated, and in any event, we had to be. So it was sort of happy marriage that regulation was a way to go. And having been regulated, I think we owe an obligation to the regulator and to the wider sort of stakeholders to help them. Because if you're the first, you're sort of trailblazer, and I think very important then that you can try as far as you can to feedback whatever you can feedback to the regulator to help them think about how to regulate in a way that will lead to a good world. I mean, and by this I mean a sort of world where there's an ecosystem of regulated law tech products. Because I think the risk of AI, it's not, as some people have suggested, that it's going to make lawyers redundant. It's not going to do that, I don't think. I've never thought that. I've thought, if anything, it'll probably lead to more work for lawyers. The risk is that a lot of people that, if they can't afford legal services, they will use things like ChatGPT to try and muddle their way through some very difficult processes and problems. And those products, they're great at what they do, but they're not designed for that. They're not regulated, and they can lead people astray and possibly make a bad situation much worse. And so I think that's a challenge, to sort of have a regulated ecosystem there where people can there will be a product or many products in each area where people can go and they can get the support that they need in a safe and responsible way. And so with that in mind, I mean, one of the things the SRA asked is, could we have not just an annual sort of catch up when your regulation comes up for renewal, but every 6 monthly one to see how you're doing. And I said, well, why don't we go one better than that and do it quarterly? Because that way you can hear every 3 months what's going on and get feedback and not just sort of keep an eye on what we're up to, but also learn things from it. And so we've been, obviously we're limited by what we can say because of client confidentiality, but we can still give the SRA a lot of anonymised but useful data about how we're doing, how many claims are going through the platform, what the shape of the claims are, experiences we've had, things we've learned, things that have occurred to us that we think is not relevant to us but might be relevant to other regulated businesses. And so we've been trying to sort of be a sort of friendly and helpful guinea pig to the SRA. And I think they've appreciated that, because I think at the end of the day, you know, it's a bit of an experiment for both sides. And the SRA can see that this is the future and they need to be ready for it.
I just got an idea, so I'm just going to ask you, what are some, what, if you could, usually the questions go, can you name one? But like,
can you name three?
Can you name some of the assumptions that you had before you started this project, and once you actually went beyond the beta testing phase, when you released it to the public, that you have to go back on those assumptions?
Yeah, I probably can. I might have to just pause and think for a moment. So I did assume that to begin with, we wouldn't get a lot of interest from big companies. I thought, because I was thinking about sort of smaller businesses and sole traders, I thought that's who would want to try it first. And to a large extent, that's true. We've got a lot of small businesses on the platform, and it's very satisfying because, of course, we built it to try and solve their problem. But actually, quite a lot of much bigger businesses have come on anyway. And I'd assumed that they wouldn't start to appear until, you know, we'd been around for a while and proven that everything works and stuff. But actually what that showed me is that there is a big problem here. There's a big gap, and actually suddenly there's a solution. And obviously big companies want to have a solution as well. So that was a pleasant surprise. Let me think, what else? So yes, I mean, I'd sort of assumed that the courts API was less effective than it actually is. So that's a nice technical thing. That actually the CNBC in I always forget whether it's Northampton or Nottingham. I think it's Northampton. It is a lot better than I feared, because it is quite an old API. But even so, it's still not as good as it could be, and I know the court service is looking at working on that. And another thing I'd sort of assumed was I'd sort of assumed that users wouldn't use Garfield like we do internally. So we're so used to it, we just do it really quickly. You know, we put invoices on contract. We often preempt some of the questions Garfield otherwise ask, and then Garfield generates that for action. What we've discovered is that users very quickly move to using it exactly the same way we do, without any prompting from us. They just use it a couple of times. They spot how to use it much more efficiently, and then they do that. And in fact, some of our users use it far more efficiently than we do. So I think sort of last autumn we publicly gave an example of a user who had got to the point where he generated a letter for action for £7,500, which is, you know, reasonable chunk of money for that business, and they'd spent in total from the moment that they started the claim to getting paid, they spent less than 4 minutes. Now, 4 minutes to get £7,500 is a heck of is an enormous time saving. Whereas if you had to engage a law firm, you have to spend an hour at least to even get anywhere near meeting a lawyer. Now, and actually, if anything, I think they've reduced the time since. I saw a user the other day that created a chaser in something like 30 seconds. And we're trying to improve the speed of Garfield all the time, because the whole idea of this product is sort of efficiency and time saving. And we almost want to make it an extension of someone's accounts function. So they just think, counts function, issue invoice, wait for payment, send out polite chaser, send another polite chaser. Okay, escalate to Garfield, get paid that way. Which is where we come on to outcomes as a service. But yeah, I wasn't expecting users to so quickly become so fluent with it that actually they outperform our own use of it.
Okay, so then I have only one more question, which is when are you expanding to Spain and Netherlands, which is where I am?
Well, I don't know. So we've had an awful lot of global interest. I mean, Dan did a little map the other day of all the countries where people have written to us and said, can we license this, or when are you coming, and those sorts of things. And a very large chunk of the world was coloured green by the end of it. And I was a bit taken. I mean, I've obviously been fielding those emails, but I was a bit taken aback at the level of interest. I think in terms of expansion, again, it's a go slow to go fast thing. I think we would look at other common law jurisdictions first, just because they're so much more similar to England and Wales. But there's no reason, we built Garfield in a modular way, there's no reason why it can't be adapted for pretty much any jurisdiction. It would help very much if the jurisdiction had APIs for the court system. And I don't think many have got that yet, but I imagine that it will come. And it will come probably quicker than people think. But yes, one day maybe. We'll see. Yeah.
Good answer.
Yeah.
But yeah, it needs to have quite a lot of boxes checked, so you could expand fast and still maintain the quality, because otherwise you're just like, you only have limited resources like every other business in the world, right? So you have to spread them in a very smart way. So you can't just tackle everything at the same time. It makes no sense. Or you're going to end up with a very, very lousy product in the end, which is pretty sure not what you want.
Yeah, we've taken the opposite approach. I mean, all lawyers are a little bit perfectionist and OCD to some extent, and I suffer those I don't know what you call them, curses or blessings, as the case may be, and so do my development team. And so we're much more focused on getting this product to a point of, if not perfection, at least something approaching it. And actually, all the time, our user base is growing constantly all the time. And if anything, it's accelerating the growth. It's definitely accelerating given what's happened this month so far. But we listen to our users a lot, and they always come up with good ideas and suggestions. And so we're spending a lot of time building extra functionality. And one of the big things we spent the last 3 months doing is just building functionality for volume users, because we had people come on and said, we don't want to just issue one claim here and there. We want to issue 100. We want to do 100 a week or something. In which case, you need to give them the ability to bulk upload claims. You need to give them payment mechanisms where they're not having to pay per claim, because that would be very painful for them. Give them reporting functionality, all sorts of things like that that we've built as well. So, yeah, it's basically refining the product, making it better, and then once it's good, it's really, really good, then we move on to other things, which will be happening fairly soon.
It's funny. I always like to say, to develop a concept or a minimum viable product, you need maybe 2-3 engineers. But if you want to maintain the same system, because it will grow, you need
you need a lot more. Yeah, exactly. I think obviously the numbers needed has reduced because of things like Claude Code nowadays. I mean, if you look at that's like 10 or 100x the ability of a developer, which is just amazing. I've seen loads of vibe coded stuff appear, and okay, it's not production ready, but still the way you can knock up a prototype and then refine it.
Yeah.
And somebody like Anthropic, they've worked out that one of their biggest customer bases is developers. They're just going to keep refining that product, refine it until it can just bash out production ready code for you. But even not being at that stage yet, its ability to do things like bug test and propose solutions and save you. So one of the jokes I've read software developers talking about is that they spend a lot of time just tabbing their way through stuff that things like that are proposed, and I think that's a massive productivity gain.
It is. It's like having. I am usually on the cautious side when it comes to AI, but I'm just going to say that I feel like you don't really need junior developers.
Yeah.
If you have seniors with Claude Code. literally.
Yes. Yeah. And then you enter the question of how do you train junior developers? And I think the answer to that is that junior developers just won't be junior developers. They will come out of a comp sci degree and they'll have all this extra stuff. And I think it's going to be very important they still learn all the basics. And actually, one thing I've noticed is that sometimes, not with my team, but just talking to other people, some junior comp sci people haven't sort of got too close to the metal. They've not really understood the basics of how a computer works. And I think that's probably a mistake by whoever provided the degree. They should definitely do all that. They should start with transistors and work their way up from NAND gates and do all of that. That's really valuable to understand the basics of how it all works. But then they can just start doing code. And okay, they won't be instantly producing production ready code, but they'll be producing good code that someone slightly more experienced can just look over and say, well, you want to change this, change that, and they'll very rapidly they just jump up quality much more quickly, I think.
Yeah.
And I think that will apply to lawyers too.
I wanted to ask, do you feel the same with lawyers?
Yes, I think one of the things about AI is it's going to improve the average quality of lawyering, because if you've got an AI looking over your shoulder, let's say you're there's quite a lot of lawyers still. They're a minority, but there are bad lawyers who for example, in my world, would write stupidly long letters and include too many adjectives and somehow have the miraculous ability to pick all the worst points and run them too hard. And an AI looking over their shoulder will be like, you shouldn't put those adjectives in, and the judge won't like that, and you should. That's not the best argument. This is the best argument. So it's gonna lift everyone's boat on the sea up. And that's going to be, I think, a good thing all round, actually.
Yeah, that's a very damn it. Sometimes I hate it that I'm not a native speaker. I'm missing an English word now, but that's a very good observation. Basically, that simplify it, because that's exactly where I saw the benefits of AI when it first appeared, Gen AI, and I'm still seeing it here. Like it raises the low bar.
Yes.
So much.
Yeah. Indeed. And it's a productivity gain for the species, as long as it's used right.
Yeah. Okay, I really appreciate you coming here, and I don't want to, keep you too long in this conversation, but I do have one more question,
Sure.
And that's maybe going to be a bit harder to answer, but, let's just speculate a little bit. If we have this conversation 2 years from now again,
okay, yeah.
what do you think? What do you think is going to be the naive thing how we used to look at AI?
It's difficult, isn't it? Because you can't predict the future, and technological development is non-linear. It just suddenly jumps. There's a sudden breakthrough, and I like. It's important that I like to give the example of the steam engine. I mean, the steam engine is basically just a giant kettle with wheels bolted on, and it basically started the Industrial Revolution. That and factories and things, and yet we've known about kettles as a species for thousands of years. Just no one thought to put wheels on it. Just like no one thought to put wheels on luggage until fairly recently. And I'm old enough to remember when everyone had to carry their luggage around by hand, and now you'd regard that as insane. And so, you just can't predict when technological development will happen and how big and what impact. I'd be surprised if there isn't some significant jumps in the next 2 years, because there's been some big jumps in the last 2 years. And we might find in 2 years' time that we're looking back and we're saying a lot of the early problems that people were angsted about are not problems anymore. So hallucinations is the big one, particularly for lawyers, because obviously we strive for perfection, and you can't mistake facts and things or mistake the law. And I think that hallucinations is one of those things that is never going to completely go away, because it's inherent in the probabilistic nature of LLMs. But technologies will be built that will reduce it so much that these things will operate at a superhuman level anyway. And once technology is operating at a far better level than humans, then you don't have to worry about the minor incidents of errors so much. So I think that as a topic will disappear. And I think we'll just see LLMs appearing in more and more things, including in things that it's really silly to include them, because what it's like. It's like my washing machine has an app. I've got no idea why it's got an app. I think that's just a classic example of a solution looking for a problem. And I imagine someone will put an LLM in a fridge or something. So it would be like, you need to buy more butter. It's just like that. And I'm just like, do we really need that? But people will do it.
That's a great way to end it on a humoristic note. But anyways, like a lot of food for thought here for our listeners. And thank you so much for taking the time to go deep into these topics with me. And that was Philip Young, the co-founder of Garfield AI. If there's one thread running through this conversation, it's that legal AI only works when the system is well-defined, bounded, and designed around reality, not just ambition. Thanks for watching, and see you next week.